for joining our session. I'm really excited about the discussion that we have coming up, and I think we have a lot of territory to cover, so I'm going to jump right in. First, I'm going to introduce our panelists. Then I'm going to briefly set the stage by introducing, for those perhaps less familiar with the concepts, a few definitions of internet intermediaries and an introduction to the three prevailing models of liability. And then we're going to turn to our panelists who've each prepared about 5 or 10 minutes of presentation on some specific case studies from their countries, from the region. And then we will open it up a little bit to think of things a little bit more globally, a little bit more thematically, and to save some time, hopefully, for discussion and questions at the end. So I'm joined today by 4 really extremely interesting panelists and experts. Vrinda Bandari, who's the counsel at the Internet Freedom Foundation, which is really one of India's leading digital rights organizations that campaigns for freedom of expression and the right to privacy online. She's an expert on information technology law in India. Damar Juntaro, who leads the Southeast Asia Freedom of Expression Network, or SafeNet, based in Indonesia. SafeNet has documented internet freedom issues across the country and the region through research, advocacy, and strategic litigation. And also Premesh Chandran, who's the CEO and co-founder of Malaysia Kini since 1999. With over 1 million visitors per month, Malaysia Kini is really the leading independent news outlet in Malaysia, which is an otherwise tightly controlled media landscape. And Malaysia Kini has been targeted by judicial harassment because it is a leading independent voice. And finally, Dr. Kyung-Sin Park, who's the co-founder and director of OpenNet Korea. Dr. Park is also a professor at the Korea University Law School and an academic member of the Global Network Initiative, among many others. My name is Michael Castor. I am the Asia Digital Program Manager for Article 19, a global freedom of expression organization, where I manage our work on internet freedom and digital rights in Asia Pacific. And I'm also joined by my co-moderator and colleague, Jen Domino, with the International Commission of Jurists. And Jen, please step in at any time if you'd like to add anything throughout the session. So as I said, before getting into the meat of our panel, I would just like to set out some brief definitions of terms and concepts, which I think will be helpful for some of our participants. So firstly, touching on the 4 sort of main types of intermediary. When we talk about intermediary liability principles, it's valuable to begin with an understanding of really who are the intermediaries, or what are the intermediaries that we're discussing. And these generally are internet service providers, or ISPs, which is the term commonly used to describe the access providers, or those who control the physical infrastructure needed to access the internet. We also have web hosting providers, or the hosts, which are companies that will rent web server space for customers to run their own websites. And the term host has also taken on a more general meaning, such as those who control websites or web pages in other forms, such as social media platforms, or a third type of intermediary, and search engines. Intermediaries, such as these 4 categories, are distinct from the content producers, or those actors that are responsible for producing or creating information or content that is then hosted by intermediaries, who under certain liability regimes would then be more liable for the content that they have created. The 3 main models for liability that I think is useful just to sort of have in mind before we discuss specific legislation in the region would be the strict liability model, which is where internet intermediaries would be liable for all third-party content. This model is used in Thailand and China, for example, And under the strict liability model, intermediaries are required to monitor content to comply with the law. If they fail to do so, they may face penalties or sanctions from loss of business license to criminal penalties. The second model of liability is known as the safe harbor model, which grants intermediaries limited immunity, provided they comply with certain requirements. And this is at the heart of the so-called notice and takedown procedures, which can be subdivided into two approaches: a vertical approach, which applies liability on certain types of content, such as copyright infringement under the US Digital Millennium Copyright Act, or the horizontal approach, where different levels of immunity may be provided to different actors, such as total immunity for access providers, such as ISPs, but limited liability, such as for social media platforms that fail to act expeditiously or quickly to remove certain types of content. And briefly worth noting that under the safe harbor model, conditional immunity is often granted for companies that will apply technical solutions, which often involve automated filtering software. And this raises additional questions or concerns around the design and implementation of these algorithms or the transparency of third-party auditing. And finally, the broad immunity model, which effectively grants full immunity for intermediaries, treating them as messengers and not as the publishers. The Manila Principles on Intermediary Liability exist as a guide of best practices in terms of the above, which are 6 principles that we don't have time to get into in detail, but effectively establish that intermediaries should not be held liable for third-party content, that any content restrictions, removal should be necessary and proportionate and based on international human rights norms. And we'll hear a bit about how these different types of principles apply in the region. So without that, I'd like to turn to our first 2 panelists to speak, Vrinda and Damar, to paint a picture of what is happening in India and Indonesia in terms of intermediary regulation. Vrinda, would you kick us off?
Yes, thank you so much. I apologize to everyone for the beginning that my video is off. I'm facing some technical problems, so I'm not able to switch on my video. As Michael pointed out, there are different models of intermediary liability, and India follows sort of the safe harbor model, but with higher obligations on intermediaries. And there are also some violations, I believe, of the Manila Principles. In 2011, India had enacted certain changes to our safe harbor intermediary model, and we had enacted certain rules. However, under those rules, as they were interpreted by the Supreme Court in a famous judgment called Shreya Singhal, the notice and takedown approach was not permitted. Maybe somebody's audio is on. So what the Supreme Court said was that if an intermediary receives actual knowledge, quote unquote, actual knowledge, which is the standard in the law, then they must take down content. However, actual knowledge was interpreted as knowledge of a judicial order. So they said that the notice and takedown approach, where any complainant can simply file a complaint, any user can simply file a complaint with an intermediary, and the intermediary had to take that down, would not work, because that would mean that intermediaries such as Google and Facebook would be inundated by multiple and millions of requests. A subsequent judgment called Google versus Vishaka of the Supreme Court reiterated this principle, saying that we do not want intermediaries to become super censors, and hence a notice and takedown approach will not be permitted. And hence you need a judicial order or the other statutory language, an order from a government agency before you take down content. In 2021, the government enacted new rules of intermediary liability, which are not as part of a parliamentary legislative amendment to the Information Technology Act, but have been notified as part of executive delegation of the powers of the government. Under the new rules, there are 2 problems with the intermediary liability. I should mention that I'm part of a challenge. I'm part of a group of lawyers who is challenging the intermediary rule. So any comments that I make should be taken in that context with that bias known. However, the grounds on which the rules have been challenged are primarily twofold. The first is that the rules go beyond the scope of the Shreya single judgment, and they go beyond the scope of the earlier rules by bringing back a notice and takedown approach. So under the rules, all intermediaries must set out certain principles in their terms of service, and they must tell all users that any content that is patently false or untrue, any content that is defamatory or obscene, cannot be posted. So they have to incorporate certain terms. Then there are three ways of taking down content. Either the intermediary can voluntarily take down content on the fact of a violation of terms of service. Whether an intermediary does this or does not do this will not affect its safe harbor status, because this is voluntary takedown by the intermediary. The second, which is incorporating the Shreya single rule, which is that if an intermediary receives actual knowledge of certain unlawful content being placed by a court or by an agency of the government, they shall take down that order they shall take down that content within 72 hours. This is also in compliance with the Manila principles, which says that content should only be taken down after there has been certain judicial oversight or judicial review of the request. The third part, and the justification for this really has been fake news and all of those sorts of problems. The government has used that to say that every individual, any user, can file a complaint for the violation of any of these rules, and the duty of an intermediary to quote unquote do due diligence. And if a user files a complaint, an intermediary must acknowledge and respond to the complaint and decide the complaint within 15 days. If the complaint pertains to any content that represents full or partial nudity, so we do not know what partial nudity means, but if it involves anything to do with partial nudity, anything to do with other certain child sexual exploitation materials and morphing, then the intermediary must take down the content within 24 hours. So apart from the fact that this goes beyond the Shreya single judgment and the general principle, and it reverts back to a notice and takedown approach, the obligations on the intermediary are increased, because under the law, any intermediary with more than 50 lakh users is classified as a significant social media intermediary. I believe that's 5 million users, which is a very low threshold in India. And all these significant social media intermediaries have to appoint a grievance redressal officer, a chief compliance officer, and a nodal officer, all of whom will be based in India. So every intermediary must have an officer, 3 officers based in India, and hence subject to law enforcement requests in India. This is then also creating a concern where the compliance officers will actually be subject to police harassment potentially. There is a fear that they may be subject to police harassment because the officers will be there in India. And we believe that is going to then cause a super censoring of content, where every request, the intermediary's commercial interests will really be to take down content. In fact, it is interesting that none of the intermediaries have challenged these rules for whatever reasons, and a bunch of users have challenged these rules. The only rule that has been challenged by an intermediary is WhatsApp, and that is Rule 4.2 of the intermediary rules, which says that an intermediaries must enable the tracing of an originator of information, so that the first originator of all the information in India must be traceable. And WhatsApp's argument and our argument in court is also that this will undermine end-to-end encryption, which is a good in itself. And this will undermine end-to-end encryption because to enable traceability of originator, all intermediaries must then be able to track the flow of messages between different users. So these are the two general big grounds of challenge. As Michael pointed out, there is also an obligation, although it's not a mandate, it's not an obligation, it's an endeavor. So all intermediaries shall endeavor to provide automated filtering for takedown of content. So those are also other obligations that have been built into the law. The other last point I want to make in the 30 seconds that I have left is actually that in the guise of these intermediary rules, the government has also added a part 3, which regulates digital news media and OTT over-the-top platforms such as Netflix and Amazon Prime. So interestingly, under the guise of intermediary rules, the government has expanded the scope of regulation beyond the Information Technology Act to really start regulating content online without having any parliamentary discussions. So these are some of the challenges. The matter is in court. Final arguments have not been heard. There is certain parts of part 3 of the rules, which relate to digital media content, have been stayed. However, part 2 is broadly in force as of now. I'd be happy to take any questions at the end. Thank you so much, Michael. I hope I stuck to my 5 minutes.
Thank you. That was a tremendous amount of territory and very fascinating in a short period of time. Damar, how would you compare the state of intermediary regulation in Indonesia with what's happening in India? I mean, some of the recent regulations in Indonesia have been incredibly restrictive and have introduced very alarming degrees of notice and takedown. And I know that you've published and we've contributed to supporting some advocacy that you've done. Can you tell us what your concerns are around intermediary regulation in Indonesia right now?
Thank you, Michael. Compared to India that have a safe harbor model, I think what happened in Indonesia, the situation for intermediary liabilities is goes to the strict model that follows the China or follows the Thailand. So usually intermediary only threatened by the government with blocking access and also obligation to pay tax. But now in the midst of COVID-19 pandemic, in 2020, the Indonesian government through the MICT, the Minister of Communication and Informatics of Republic of Indonesia, passed on a new minister regulation number 5 of 2020, or we simply call MR5, concerning the private electronic system operators. So there are 4 main concerns from SafeNet about this MR5 as a key challenges for intermediaries. The first one is registration is required right now, forcing local jurisdiction. Means that through MR5, it governs all private electronic service system operators, which include a broad grouping of the services, including social media and other content sharing platform, digital marketplaces, search engine, financial services, data processing services, messaging, video, and gaming services must register. The ministry has the power to block access to the platform if a company fails to register. So this registration requirement may create administrative challenges for some companies, and it is unclear how the government intend to enforce this until now. The second concern is about the lack of clarity. Inside the MR5, specifically Article 9.4, it defines that prohibit information and content as any that in violation of law and regulation, and then the second one, causing public unrest and disturbance of public order. And for this one, the causing public unrest and disturbance of public order is actually being self-defined by the MICT as that has a regulatory power. It gives the entity with enforcing of the law power to dictate the legality of the speech. And we also concern that Article 9 inside the MR5 that suggests that electronic system operators will not be allowed to disseminate or facilitate dissemination of any information providing access to prohibited electronic information. This could potentially include information regarding of the use of VPN, virtual private network, which is widely used right now for legitimacy, privacy, and security reason by many Indonesian businesses and individuals. The third reason is the unreasonable timelines. So the ministry and the MICT has granted itself the authority to require any business entity that operates electronic system operators to restrict or remove any content deemed to be in a violation of Indonesian laws within 24 hours. Even the ESOs is also expected to respond within 4 hours to urgent requests. So this including to content that related to terrorism, child exploitation, and any content that causing unsettling situation for the public and disturbing public order. If an ESO do not respond, if a company do not respond within that time frame, so the government can order an ISP to block access to the service. And then the last one, the last main concern is that the government can access to data. So under MR5 regulation, it requires the ESO to grant access to their system and any data for supervision purposes whenever the authorities request it. Under the MR5 regulation, this provision can access not only data that stored inside Indonesia, but also stored outside Indonesia, as long as they are related to Indonesian residents and also business entities in Indonesia. So also about this, if the companies do not provide access to required data or systems, so the government can write down some range of penalties. One is the written warning, and the second, temporary suspension of the service, and also termination of access. So thus, I will emphasize two final words that this is MR5 actually inconsistent with the right of privacy. It against the Article 17 of CCPR. The second one is MR5 with the heavy fines to intermediaries can have a significant chilling effect and has a great danger to freedom of expression in large scale in Indonesia. Back to you, Michael.
Thank you, Damar. Likewise, covering a lot of really, fascinating information in a short time. I appreciate you sticking to the time frame, and hopefully what you have shared will raise some, interest and ideas for questions from participants when we get there. Both of the examples that we've seen in India and Indonesia, touch really on the concerns when intermediary liability principles are abused to stifle or restrict the freedom of expression, access to information, or privacy online. Certainly when regulations are abused to pursue intermediaries with judicial harassment, all of these concerns are magnified. We've seen this not just as a possibility or as a legal analysis of the concerns that the laws and regulations have, but we've seen this really in practice in Malaysia. Pramesh, could you walk us through a bit of really what exactly has been happening with Malaysia Kini, how your platform as an intermediary has been targeted by abuse of existing laws and policies, really in violation of what intermediary liability principles should constrain the behavior of the Malaysian authorities?
Yeah, thanks, Michael, and good evening to everybody. Malaysia Kini, as you know, is a publisher. We've been around for 21 years. We publish online in 4 languages, and we have a very large readership. And we're known for very independent publishing, trying to hold the Government of Day account. We have a very active readers comment section. Here is where paying readers, subscribers are allowed to comment on our story. And obviously, we do some amount of filtering for profanities and foul language. And we do go through our content for, statements which are racist, or insulting in terms of religion, etc. In last year, in 2020, during the pandemic, Malaysia Kini was charged with contempt of court because in an article that we wrote about the judiciary, reopening the courts after the subsiding of the pandemic. Some of our readers criticized the Chief Justice in an unrelated case. There were certain politicians which were left off the hook, and that was a decision done by the Attorney General. But some of our readers commented and questioned the Chief Justice, and essentially questioning the judicial system, whether or not it is accountable and it's fair. But subsequently to this, we were charged at the federal court for contempt of court for those readers' comments. There were 5 comments in total, saying that by having those comments there, we were liable for those comments. So what happened, in fact, was that the story came up, a few days. It was not very much of a story, but it's about courts opening, and we didn't know about it. A few days later, we got a call from the police about this particular story and about comments in the story. We then reviewed the comments, and we took out and removed the comments that we felt were libelous and seditious. But nevertheless, we were charged. So the case drew on for a long time. And early this year, we were found guilty by the federal court. And because it's at the federal court, the highest court, there's no room for appeal in that sense. And it was a 6-1 judgment. So it was one of the largest sitting of the federal court, 7 judges in total. And in a 6-1 judgment against us, they said that by having the comments there, we had inferred knowledge of those comments, and therefore we were then considered the publisher of those comments, even if those comments were made by our readers. So as a media company, we had to take full responsibility of comments by our readers on our website, whether or not we were aware on it. The knowledge that we were aware on it would have to be inferred on us, and that was the majority judgment of 6 judges. The minority judgment in our favor by one federal court judge was that we have what they call the Communications and Multimedia Act in Malaysia. And under the Communications and Multimedia Act, which among its objectives says that there will not be censorship of the news. So this was an act brought about in the 1990s when the internet first came about. And this act then created what they call a content forum. And the content forum was like an industry forum. And they then developed what they call a content code. And in this code, it says that forums, where people post contents, the forum owner is only liable if, after requested to take down a comment, refuses to take it down within 48 hours. So the forum owner or publisher basically takes responsibility for comments by third parties if they refuse to take down after 48 hours, which was not our case because we took it down straight away. And that if the publisher follows this content code, it's a full defense, in a court of law. So we relied on the content code, but the majority judges did not find it valid. They read it a different way and implied that as a media company, we must have had knowledge of those comments and therefore become publisher as soon as the comments are published, rather than we becoming aware that those comments were published. So we lost our case, and there was a very big judgment against us of $500,000 ringgit, which is about 150,000 US dollars fine against Malaysia Kini, very much above and beyond what would normally be, a fine that would normally be allocated. But what we are doing is that we are filing a judicial review to the federal court itself, because we felt that the court did not take cognizance of the fact that the content code allows us a full defense, and there were other parts of the judgment where they inferred knowledge on our editors, which was never even brought up by the prosecution. So we felt it's a faulty judgment, and we are challenging it. I think generally speaking, in a more general situation, the question of there are a lot of readers' comments, whether it's on Facebook, Twitter, on publications, and we do not feel that having publishers really overwhelmingly restrict all the comments in a very stringent way is in accordance with our constitutional guarantee of freedom of speech. We feel that there should be some amount of freedom of speech, but the liability should lie with those making the comments themselves, rather than the publisher or the manager of the forum. So that's where we stand, and we are fighting our case, and we're also looking at the development of these sort of cases in other jurisdictions as well. Thank you.
Thanks a lot, Primish. Yeah, I mean, it's a great place to end on. Keeping an eye on the development of similar cases in other jurisdictions. As you're no doubt aware, and as some of our participants might be aware, earlier this month, Australia passed a law that would allow social media platforms or the social media posts of news agencies where people are commenting on those posts. The news agencies then could be held liable for what people are commenting on their posts on Facebook or other places, which is really an alarming, stripping away again of the same type of intermediary liability principles that we've been discussing in terms of the potential for chilling the freedom of expression, leading to self-censorship or other concerns that might come about. We'll see as the new law in Australia is implemented. And so obviously, looking at what is happening in one part of the region or other parts of the world to understand kind of how new laws and policies might be developed or implemented in this region is important. And on that note, of course, it's important to realize that none of this is coming about in a vacuum. There's a lot of rippling effect and similarity, either direct exchange and learning from in the legislative process, or symbolically or ideologically influence that we see between one piece of law and in one part of the world and another. Dr. Park, I wonder if you could talk to us a little bit about that, taking us maybe a little bit out of Asia Pacific to more of a global perspective, and how we've seen certain similar laws and policies in other places, and how they have then had an impact on restricting freedom of expression or internet freedom in this region. Thank you.
Yes, it's heart-wrenching to hear the platforms are struggling under the new restrictions in Asia, both in India, Indonesia, and I want to get to the root of that. And before I do that, let me first set the record straight that intermediary liability safe harbor. It's easy to just use the term intermediary liability, but intermediary liability is not the norm. The norm is safe harbor from intermediary liability. That is an international standard. Actually, it has become international human rights standard because the UN Special Rapporteurs of freedom of expression has emphasized the need for open space in the internet, and how the open space can be protected only when there is a strong intermediary liability safe harbor, or strong safe harbor from intermediary liability. Then what is intermediary liability safe harbor? Around the same time, both Europe and United States adopted these laws that became the bedrock of intermediary liability safe harbor. 2000 European Union e-commerce directive and DMCA, that's Digital Millennium Copyright Act. So millennium was the turn of the millennium, so it was around the same time. Section 512, the two principles percolate from these two laws. One is that intermediaries should not be liable for contents that intermediaries are not aware of. Second, intermediaries should not be required to conduct general monitoring of all the contents coming up on their service. By general monitoring, what we mean is monitoring each and every content coming up. Now, that is the bottom line of intermediary liability safe harbor. However, there was how should I say this? The penumbra of that principle is that notice and take down is supposed to be optional, not mandatory. Otherwise, it can risk becoming strict liability. What I mean is, so the principle is that intermediaries cannot be held liable for contents that they're not aware of. So some regulators may think that, okay, the flip side of that, the converse of that is maybe intermediaries should be held liable when they are aware of illegal contents. So they can start thinking about holding intermediaries liable when they are given notices of illegal contents. But that's not how notice and takedown was first invented and implemented in DMCA 512. If you look at DMCA 512, notice and takedown is optional. It is something that intermediaries can choose to enact, choose to implement if they want the legal protection for contents. But it is so, like, fast forward 20 years or fast forward 18 years, it is Germany's NetzDG or Germany's social media law or Germany's fake news law, as it was called when it was adopted. Basically, Germany's NetzDG basically went into that loophole in the intermediate liability standard, and they basically created mandatory notice and takedown law, where platforms with more than 2 million registered users have to take down all manifestly unlawful content within 24 hours and all other unlawful content within 7 days of notice by individuals, or they face fine of up to 50 million euros. Now, this mandatory notice and takedown causes the same problem that we predicted when we were talking idly about the loophole in the intermediate liability standard, intermediate liability safe harbor standard, which is that if the intermediaries are held liable for not taking down content that were just given notice of, then they are on the side of caution rather than keeping the content. So in order to escape liability, without much consideration for the author's rights, they are bound to take down more. So there is a huge over-implementation problem. And I, coming from Korea, know this because Korea has had this mandatory notice and takedown for now for 12 years, from 2005, so like 15 years. And there's a huge overzealous censorship by intermediaries. And also it has the problem of privatizing online censorship, because many requests will be submitted to intermediaries, and intermediaries, there's a scalability issue of whether scalability problem, which is that the government cannot really monitor whether the intermediaries are really taking down only illegal contents. So what ends up happening is intermediaries, without any public control, without any public monitoring, they decide what to take down and what to keep. And in doing so, they end up committing over censorship. Unfortunately, once Germany adopted NetzDG, these Asian countries followed suit. 2019, Philippines Anti-False Content Act. In the preamble, it mentions NetzDG as an inspiration. 2018 Malaysia Anti-Fake News Act mentions NetzDG. Now that law is now replaced with a new fake news law, but still the idea is the same. They are doing what Germany did. 2018 Vietnam Cybersecurity Law Also, it doesn't mention NetEasy, but it's very similar to NetEasy down to 24 hours deadline. And 2019 Singapore Protection from Online Falsehood and Manipulation Act also mentions NetEasy as inspiration. Now, it has become even worse than NetEasy because NetEasy is restricted to those content that are defined as illegal in the criminal law. Germany's criminal code defines certain contents in illegal, and NetEasy operates only on those contents. But when it came to Asia, the target contents became much broader. For instance, in Vietnam, propaganda against Vietnam, that became a target. Philippines, Malaysia, they all broadened to false content and fake news when NetEasy didn't include fake news as the target content. Same thing with the Singapore, which includes false statement of facts. Now, back in 2015, many organizations, including my own OpenNet Association and EFF of the US, got together and drafted Manila Principles as kind of international soft law on intermediary liability safe harbor. And if you read that, I mean, we really need to pat ourselves on the back because it predicts the problem that Germany is causing for international human rights standard. And one of the principles is that there should be no liability for content not touched, not modified by the intermediaries, which means even if there are illegal contents that intermediaries are put on notice by these complaints submitted by users, intermediaries should not be held liable for those. Then what's the remedy? Well, other parts of the Manila Principles say, well, if there is illegal content, the government or whoever is complaining of the harm should go to court, get a judicial order, and then force intermediaries to take that down. I'll stop there.
Thank you for that. And that's a really great place, I think, to stop, because it's a transition really into sort of the first question that we had submitted in advance. But before I ask that, I just like to, again, thank all of the panelists for each of your really excellent presentations. I hope that the participants have really gained a lot from it. And with the remaining time, I hope that we can actually have a bit of a discussion. So I encourage any of the participants who would like to flag anything, questions or concerns they have, either specifically for any of the panelists based on the presentations that they made, or if you have examples, concerns from respective countries where you're coming from, or the movements or struggles that you're involved in, please do share them. To kick off that conversation, someone earlier submitted an advanced question from one of our participants from Myanmar, and in particular they were asking about, while recognizing the importance of protecting intermediaries from liability to preserve the freedom of expression online, as Dr. Park said, sometimes that content can be illegal. Sometimes that content can incite or glorify violence against marginalized communities, such as Rohingya in the case of Myanmar, and elsewhere across the region, as we have seen. And so I think some people in the participants might be interested to hear from the panelists about how to manage from a perspective of international human rights norms when you have objectionable content that does rise to the level of either being acceptable restrictions on the freedom of expression under Article 19 or mandatory restrictions such as under Article 20. Vrinda, if you'd like to take that one first, it looks like you're interested, but again, any other panelists are also welcome to chime in.
No, I was actually saying, Michael, to answer the question that was in the chat box. I was talking about answering that question. So there was a question addressed to me, you'd asked. So should I take that after the Rohingya question?
Sure. If any, you can answer that one first if you like, and then others can think about if there's any response that you would like to make in terms of exactly basically where Dr. Park ended off as, in terms of managing both protection for intermediaries as well as expectations to deal with the potential for human rights abuses through platforms and their services. Maybe you can answer the question directed to you first, and then maybe Dr. Park, if you'd like to take on the other one.
Yeah, so just to respond to you, David, so your question is, if time allows, could I describe the current status of challenge to the new non-parliamentary order in India and a timeline to the decision? So there are multiple proceedings before multiple high courts. There is the Bombay High Court decision that has granted a stay on Part 3 of the rules, on certain aspects of Part 3 of the rules, where what they have said is that digital news media oversight mechanisms cannot be permitted. The Bombay High Court has just given an interim order. The final hearing is going to happen maybe sometime in October or November is what we expect. The Madras High Court is also cognizant of the same matter. They have also given a stay with respect to the intermediary rules insofar as they extend to digital news media and OTT platforms. They have not given any stay to the Part 2, which concerns the intermediary rules. The central government has moved the Supreme Court, where they have said that there are multiple petitions pending before multiple courts. So we want the Supreme Court to hear the decisions together, to hear all the petitions together, because we do not want to have conflicting decisions. Unfortunately, it's been more than a month, and that transfer petition of the central government has not been listed. So we're actually in a situation where both the high courts have given interim orders, and we don't have any clarity on really when the final hearing will pass. The Madras High Court has given a date for 23rd October. So we believe that if no transfer petition is allowed or entertained by the Supreme Court, we will be arguing before the Madras High Court as a final relief. And then we will argue that let the court take the benefit of the judgment of the High Court in deciding the matter. So that addresses your question. Thanks.
I can take the other question. Let me share. Okay, let's see. Actually, I guess I don't need to share that right now. I'll share. I wanted to share Manila principles, but I'll do that a little bit later. Now, so yes, striking a balance between protection of alleged victims of content and the author's rights or freedom of speech in general, which includes public's right to also access content. Well, think of it this way. When you say intermediaries, we are not just talking about Google, Facebook. Intermediaries also include telcos, telecoms, network operators. Now, imagine holding liable. I mean, let's say I send an illegal content. Let's say I upload illegal content on my blog. Yes, I'm using the services of, let's say I did that on Google blog. Yes, I'm using the services of Google, but at the same time, I'm using the services of an internet service provider who provided me with internet access, which is a local telecom company. Now, imagine holding ISP liable for all the illegal contents or activities that are taking place through their services. It will be impossible to operate a network because, I mean, we are talking about internet. Let's say I conspired to rob a bank with my friends. And I did that using a mobile phone. Can mobile network operator be held liable for assisting conspiracy for bank robbery? It will if we hold intermediaries liable, if you hold the network operators and telecoms liable for all those activities that are being discussed over their network, then the network operators cannot function, and all the people who want to use it for legal purposes will now be without any space to have a lawful discussion. Now, what you are saying is that the same principle should apply. There is no reason why the same principle should not be applicable to platform operators who are allowing who are providing the space for sharing messages among a huge number of people. Now, if there is a truly illegal and harmful content, it is also in the interest of intermediaries to take that down, because it is for the users. It is for the users' benefit. It is the popularity with the users that provide financial benefit, that provide financial protection to the platforms. So that is so one of the early principles of intermediary liability safe harbor is that intermediaries should not be held liable also for failing to take down content, or for failing to take down content, but also for keeping for failing to take down content, and also failing to retain the content. The point is that the intermediaries should be given a lot of freedom to innovate in using their technology to look for the content that they need to take down to promote their services. And intermediary liability, the mandatory notice and takedown, will only hurt the platform's ability to innovate in different with the different community guidelines.
Thank you. Govind, you have your hand up. Please feel free to ask your question. Govind?
Hello.
Yeah.
Hello.
Yes, hello.
Yeah, thanks. My question is to Dr. Park and Brinda, because what you are saying, the intermediary should not be held liable for any kind of content hosted in their platform. But the question is that if any kind of content, if you don't define a good content and a bad content, then if something law and order situation or some kind of hate speech, some kind of anti-communal things happens, then how will you deal with it, especially by the law enforcement agencies and country like India, which is a vast country, so many languages, so many cultures. So I'm not saying to restrict intermediaries or the platform, but there should be some kind of balance or some kind of way out to do the fine tuning, so that the platforms are not misused by the users as well as the government. Thank you.
Okay. If Brinda,
yeah, I would just.
Okay.
No, Dr. Park, go ahead.
Oh, well, I gave my answer actually in the previous round.
Yeah.
But I can add a little bit. Govind, as you said, there are illegal content, and the platforms that are, the intermediary liability safe harbor doesn't mean that intermediaries will not be held liable at all. The problem with the NetDZ, the problem with the mandatory notice and takedown law is that the fact that they did not take down the content, the failure to take down itself becomes a basis of liability separately from the harms coming from the content. Sorry, I don't know what that was, but
5 minutes left in the session. That was the timer.
All right. So the harms coming okay, I kind of lost track. Okay, so that there is an intermediate liability safe harbor doesn't mean that intermediaries will never be held liable for bad contents. They will be held liable under general tort law, and they should be if they are if they are hit with complaints again and again on clear illegal content that they know about. Now, yes, if you look at CDA 230 in the US, the platforms are held immune. Platforms are immune from liability even in those situations. Now, I personally think that we need to change CDA 230 a little bit, but the platforms who clearly know the legality and also the existence of illegality and existence of illegal content will be held liable. But the problem with NetDG and this notice and takedown law is that regardless of the harms coming from the illegal content, separately from that, the platforms will be held liable simply for failing to take down, and that causes overzealous censorship.
Yeah, I think that really sort of hits the nail on the head there. With 3 minutes left, I'd like to give Damar or Pramesh maybe an opportunity to leave us with a few closing words or thoughts or anything else that you would like to add. Damar, would you like to say a few final comments, and Pramesh as well? Would you like to close us out with a few thoughts?
Yeah, let me start first. So what happened in Indonesia, and I think what happened also in the Southeast Asia countries, shows that the intermediary liabilities is important issues. If we saw that many of the countries falls into the strict model, means that the control from the state is more to put the many tech platform to work under the local jurisdiction, and then it will be have a pretty big impact with the freedom of expression in particular. Yeah, you already saw the situation happen in outside Indonesia, but for Indonesia, what I'm worried about is when this will be implemented, because this is already postponed due to the public refusement of the MR5. But I think it will impact a lot of minorities. We have a lot of minorities here in Indonesia. Not only religion minorities, but also gender minorities, and all of those who working and need the internet as a space for them to channel what is their expression. So a couple of times Dr. Park mentioned about the NetDG as a model. And I agree with him that this NetDG actually being a source of inspiration. And in terms of Indonesia, I think
we have 30 seconds left. Sorry, I'm going to just jump in and interrupt, unfortunately. I just want to say again, thank you to everybody for speaking on the panel and for your questions. And for the participants to follow up with any of the panelists, of course, please feel free. I believe the official APrIGF Twitter has all of our links to our websites and so forth. So I encourage you to check the websites of SafeNet, OpenNet, Internet Freedom Foundation, and of course, Malaysia Kini. Thank you all for joining.
Thank you. Bye-bye.
Bye. Thank you.
Thank you for moderation.
Thank you.
Recording stopped.